Hearing the appeal, Goldtrail Travel Limited against Onur Air.
Mr. Gibbon.
May it please you, my lords. In this matter, I appear with Ms. Eilert for the appellant Onur Air. Mr. Miles QC appears with Ms. Stonefrost for the respondent. In terms of housekeeping, very quickly, there's a core volume, an authorities volume, an appendix, which I don't believe anybody will need to refer to. There has been electronic filing, which I hope works appropriately.
Yep.
There have been separately loose copies of the cases filed with AV references. My friend has brought along a copy of the chronology, which was in accident omitted from the bundles. If we need to refer to that, we probably won't need to, I suspect. There's also a transcript of Hamand Saddad's that was filed yesterday, I believe, on the basis it's clearer than the copy in the authorities volume. Finally, yesterday there was filed a copy of a very short case called Field Rank. So that will be loose. It's 3 pages long. It's from the days of extremely short judgments. And an apology in advance. In my notes, I've written E to refer to electronic filing. I will try and say MS, which I believe is the correct terminology.
Provided we all know what you mean, that's fine.
I'm obliged, my lord. This appeal is in essence a short, but we say very important point. Shorn of the inessentials, it concerns the correct approach into taking account of the position of a third party, in particular owners, in the context of a claim that imposition of a condition would stifle an appeal in respect of imposition of conditions under CPR 52.9. One very small quirk, which I should mention here, is that actually since this appeal got underway, the CPR has been renumbered. There is a new CPR 52, and the relevant rule is now CPR 52.18, which is found at the end of the authorities volume. That's at tab 20. The wording is exactly the same, though, so the principle remains.
Right.
On top of that, as regards this appeal, 52.9 still applies because of transitional provisions.
Right. Thank you.
Subject to your lordships, the sequence of my submissions, my oral submissions, will be this. First, very brief observations on key passages in Lord Justice Patton's judgment.
Right.
Secondly, key cases on CPR 52.9, and by that I refer to, in particular to Hamand Saddad's, Whitman, and what I'll call SOC Gen for convenience. I hope that doesn't sound disrespectful. Thirdly, separate corporate personality, which again I anticipate being very short on the basis that in essence the parties are agreed on the principal cases. Fourthly, Atlas Maritime, namely looking behind companies for some legal reason, and again I propose to be short on that. Fifthly, MV York, and this is by way of response to my learned friend's principal point, if I can call it that.
Yep.
Sixthly, summary points of principle. I really intend those to be summary points of principle in the light of what I've gone through. And seventhly, again, briefly, to say how in that context his lordship erred in the decision below. So that's the shape, subject to your lordships, of the submissions.
Thank you.
Going straight to the decision of Lord Justice Patton, that is found in, I'll give core volume number first, it's tab 6. Bad start. That is tab 7, starting at page 89.
Yep.
And just by way of introduction, my learned friend has said there's a misconception on the part of the appellant as to what the Lord Justice had to decide and how he reached his decision. I'm not going to argue that. I'll simply agree with him that close focus on what he said and the reasons he reached his decision are necessary. I'll show you the key passages, but rather than have a forensic debate between myself and my learned friend, your lordships will see what was said. The key passages are in particular paragraphs 24 to 29, and that's A96,
Thank you.
which is MS 102. Now, your lordships will have read these passages, so
Yes.
I won't read them out. And I stress at the start, there's no challenge to any of the factual findings. One's simply dealing with points of principle. Lord Justice Patten had concluded that Mr. Begana had decided not to fund.
Yes.
And he said if you can take account of Mr. Begana's position, then the application can't succeed.
I mean, on the paragraph 23, sets out Mr. Begana's the evidence in relation to his position. That's sort of all we have, is it? As to Mr. Begana doesn't give any very clear reasons for, other than that he says it's contrary to his human rights under the convention, which is not a point you're taking, I think.
It's not a point I'm taking, my lord. In fact, that quote is from Ms. Erguven,
Yes,
who's
I
the
understand.
CFO. So there's no direct evidence from Mr. Begana, who's not a party. As you've seen from the evidence, of course, did put in a witness statement on which he wasn't cross-examined because of illness at the trial. So that is the evidence, and I don't challenge the conclusion that is reached by Lord Justice Patten as to what his means are.
The conclusion that
I don't challenge the conclusion that was reached as to what his means were. I can't on the material. So I work on the basis that he's a wealthy man.
So the evidence of Mr. Begana's subventions comes from Mr. Oakley Smith.
That's right, my lord.
And then in second half of 23, we have Mrs. Erguven's evidence.
That's right. And the sequence was this, that Mr. Oakley Smith put in evidence. I won't go over the procedural chronology precisely, and that's from Ms. Erguven's second statement in response to him. The reason why Lord Justice Patten says if I can take account of his position then the application can't succeed is why we're arguing about 52.9 rather than 3.17, because effectively he says, well, I approach it as to what the considerations would be under 52.9. Now, the next point I wanted to draw particular attention to is the quotation at 27, because you'll see there that what Lord Justice Patten said, having mentioned the SocGen case, one of the issues is whether the appellant company had wealthy owners who could pay the judgment debt. Now, my friend makes observations in relation to SocGen, which I'll come to in more detail later, but in terms of how these cases are read, both by advocates, dare I say, and busy judges in the Court of Appeal, I'd suggest that that is how these cases are read. The issue was whether the appellant company had wealthy owners who could pay the judgment debt. And the phrase, as you can see there, specifically was, does SARD, a well-known company, have wealthy owners, and was there evidence that they could not, if minded to do so, pay the judgment debt on behalf of the judgment debtor corporate entity? And an important point, and again I say this in relation to how these cases are argued, and I apologise for taking you out of sequence slightly, but if you go to tab 9, page 226, which is MS 315,
Yes.
you'll see that my learned friend, Ms. Stonefrost, who dealt with the matter in the Court of Appeal, specifically made that point in paragraph 26 of her skeleton argument for the hearing before Lord Justice Patten. So that's towards the bottom of the page.
Could not is emphasised.
Could not is emphasised.
Yes, thank you. Yep, thank you.
Now, returning to page 96, 97,
Yeah.
2 points I just wanted to emphasise in the course of paragraph 54 in the quotation from SocGen. At the top of page A97, you'll see the phrase there, the difficult question of principle as to whether or not this court can legitimately impose a condition that a judgment debt or part of it be paid into court where effectively this will require an owner or others, such as a director, to fund that condition.
So sorry, which paragraph is that?
It's the top of page A97, so it's the first of the quoted paragraphs.
The very first word on A97.
My lord, indeed.
No, I see. This is Lord Justice Aikens.
Yep,
Yeah.
yep.
And similarly, within that paragraph, I haven't counted the lines, but about 2/3 of the way down, furthermore, the right to enforce is, at least in the first place, only exercisable against the assets of the actual judgment debtor, not those of any other entity.
Understood.
And then the next sentence to emphasise, which has the practical effect that a third party will provide the funding, an indirect way of enforcing, etc. So again, in terms, we say that what was recognised there is that an artificial distinction between what's really going on and what may be said to be going on is not appropriate. Effectively, what is happening is this. We say is what's being talked of.
So I can't hear that.
I apologise, I got a slight sore throat this morning. I perhaps phrase it slightly better. It was recognised by the court that the effect would be as described.
Yes, that the owner has to put up the money.
Yes. So that those 2 points show that although technically the owner is not the subject of the order necessarily, that's what's effectively going to happen. Now, I don't want to say anything else about those passages which your lordships have read. Perhaps to note one further point, which arises on this appeal, but perhaps didn't arise in quite the same way in that matter that was quoted, is that the SocGen passage doesn't attempt to distinguish between two related points as to wealthy owners, namely, first, whether they have been approached at all on the question of access to funds, and second, whether they have been approached but have said no.
I understand.
And obviously, in this case, the evidence is that Mr. Bergana said he wasn't prepared to provide further. Now, I wanted then to move to the Hammond-Suddard's case.
Right.
There is a head note, and I was going to start with the head note, which is in the authorities volume at tab 7. And this is MS 488.
Right, thank you. Yes?
Now, I was going to ask you to cast your eye across the headnote. There is one error in the headnote, unfortunately, which is at the end of the third paragraph. There's an incorrect reference to a second order for security for costs, which had been made, in fact, at a previous time. The subsequently, I think, is apt to mislead.
Previously, we should write, should we?
Previously, perhaps, would clarify, my lord. I'm very grateful.
Sorry, where is that?
That's the end of the third paragraph of the headnote.
Master Leslie, previously.
Previously.
Right.
And that was a security for costs order that was secured by some form of guarantee. I was going to suggest that your lordships, rather than listen to me, simply cast your eyes across the headnote of Hammond-Suddard's, given we're going to mention it so many times, just to have an idea of the facts.
I see the recording of it being Miss Justice Silver sitting also with Lord Justice Clark and Miss Justice Wall is wrong. It's an appeal from.
It's an appeal from. I suspect Lord Clark may have a better recollection of that than I could possibly improve on, but that appears to be right.
It was as the Britain case would suggest, it was a two-judge court. Right?
We were looking we were looking for a hard copy of the civil procedure report, and this was the best we could find. Maybe the original version.
Well, somebody's produced for me a slightly different. It's just the judgment.
I was about to say,
we've got certainly were only two judges, namely myself.
I struggled. I felt like a very old man. I really struggled with this particular type, and so I caused my assistant to print off a proper copy of this. And in fact, without my asking, she typed up the headnote that you're asking us to read, and I tipped off Lord Clark about that. So he's got it too, but I'm not sure any of my other colleagues.
Well, all I can do again is apologise that wasn't.
Sorry, I've actually brought along copies of the official transcript, which are much easier to read. I had the same difficulty in trying to read this copy. I don't know whether you want those or not, but If you do,
got them.
It's on Bailey. It's on Bailey, isn't it? So,
It is, yeah.
And I was certainly going to move on, having shown you the head note, to the proper transcript, because, as your lordship saw, I myself found myself taking my glasses on and off to have a look at it.
Okay.
So it was really just to get the benefit of the head note as a summary,
Benefit's the right word, yeah.
if that's the right word.
Thank you.
So I was going to move then to
Well, I've got this actually.
Yes?
to the helpful transcript. I mean, the context, I should say, is this. CPR 52, as your lordships will remember, came into effect in May 2000.
Got one, okay, I'll have one.
Yes.
Slightly after the introduction of the first tranche of the CPR. And CPR 52.9 was introduced then, and there was no direct equivalent under the RSC of this provision. And certainly based on our research, is Hammond-Suddars, which was decided 18 months after the introduction of the CPR, seems to have been the first case concerning payment in of judgment sum as a condition under 52.9. Certainly it's the first case that's regularly cited.
Okay. Yep.
Are you implying that there was some new provision in the CPR, in relation to which there's no analogy in the previous rules?
I'm certainly not saying there are no analogies, but there is no provision the same as it, whereas, for instance, in relation to security for costs, one can go back and there was a security for costs provision, which was
But what
essentially
about paying the
replicated.
judgment debt in? That was nothing new in the CPR, was it? I mean, there was a general provision about...
There were discretions as to conditions,
Yes.
but the particular point, perhaps I'll develop in further later on, is that in the context of any individual discretion, it shouldn't necessarily be assumed that analogous situations should be treated as exactly the same. So I say I'll develop that in the course of submissions. But the only point to make is there was nothing exactly the same before in relation to 52.9. Now, I'm not going to run through comparing and contrasting the position of Agrichem and Onur because that wouldn't be of assistance. I'll simply emphasise key points. At paragraph 16, and I haven't got numbers for the transcript, page numbers, but you'll see there that there had been previous evidence in relation to Agrichem recorded, paragraph 16,
Yep.
that it was owned by a discretionary trust, the beneficiaries of which were members of one family. The trust has substantial assets and no borrowings.
Yep.
And the phrase on the following page describing that, top of the next page, is substantial wealth. So that's the equivalent to substantial assets,
Yes.
but the phrase wealthy is what you see later in the decision. The Kiri case was mentioned in the context of stay, and
Paragraph 27, yep.
27 onwards, indeed, my lord. And
The security for costs.
it's a security for costs case, and that's where it was mentioned. And then the section on payment of or security for the judgment debt comes from paragraph 34. There was an initial argument about whether the condition could be opposed at all, which was rejected.
That was the first point Lord Justice Clark identified as being the first of the 2 points of principle, yep.
My lord, yes, but I simply want to go straight to paragraph 41.
Of course, yep.
Now, this is what's described as a list of facts, and perhaps it's the way of things, but I'm sure that when this was set out, it was simply set out as a list of facts. The way the law tends to develop is that later on, even if one expresses caution, they can get solidified, if you like, into factors. The two I wanted to emphasise in this context were number 3, first of all.
Yes.
There's no convincing evidence the appellant does not either have the resources or have access to resources which would enable it to pay the judgment debt and costs as ordered.
Yes.
And then the last sentence of 4,
Yes.
as wealthy owners, there's no evidence that if they were minded to do so, they could not pay the judgment debt, including the outstanding orders for costs. Now, one doesn't want to over-analyse this, but I respectfully say that actually the second of those things I've quoted wasn't necessary to the conclusion in Hammond-Suddards, and that's in the light of the conclusion at subparagraph 3. In a sense, it's a negative fact, for want of a better phrase, and certainly the decision isn't attempting to grapple here with, we would say, whether the wealth of an owner should always be taken into account. At the risk of overanalyzing, there does seem to be a tension in that second sentence between the idea of having a wealthy owner and at the same time that wealthy owner could not pay the judgment debt, though possibly one could imagine situations of illiquid wealth where there was some difficulty in providing. And also we would say, and again this is no criticism of the Court of Appeal in the facts of the case, but if you like, how lawyers read it, dare I say, and speak as somebody at the practicing bar, there is an ambiguity as to whether the payment is to be direct to the claimant or to fund the appellant company. Now, at paragraph 43, what one sees is the exercise of discretion if there's a compelling reason.
Well, is it relevant at the end of 42? Talks about willing and able to use resources from others, including perhaps its owners. Anyway, yeah, you want to go to 43?
I'll come back to that, my lord, if you wish. But 43, simply to emphasise here the phrase, we see nothing unjust. It's about...
or inconsistent. Yep.
Indeed. And if it's in the interest of the appellant for the appeal to continue, the trust must procure the payment of the current orders. So that concertinas the interests of the appellant and the trust must procure. Yeah. And again, and I don't want to overemphasise this, it seems to be indifferent as to whether that should be a direct payment or a two-legged payment. I do note as well in 45, and this comes back to my point about the numbered point 3 that I read out to you, we'd also add that the position would be very different if the appellant were able to produce convincing evidence the appeal would be stifled if it were required to take these steps. And it says that if evidence of the type available in Curie had been available, the position might well have been different. And the key point here is the evidence put before the court does not show that these orders will stifle the appeal. Now, we respectfully suggest, based on that, there are two strands, if you like. What is the true ratio of Hammond-Suddards? And we respectfully say that it's an appellant who claims stifling and who fails to put forward cogent evidence that he can't access money will not demonstrate stifling. But the impression that's left is that it will always be for the company to show that its owner or relevant backers, assuming them to be wealthy, could not pay even if they wanted to. And I've referred back to the submission made by my learned friend in relation to the Court of Appeal hearing. One last thing before I move on. At paragraph 48, and this, if you like, reflects the timing of the decision, I'd respectfully say, because it was shortly after the introduction of the CPR, and the courts were rightly concerned to emphasise the disciplines of the new regime. 3 or 4 lines in, we do, however, take the view that the new regime of the CPR, with its emphasis on the timely payment of costs and the use of costs as a sanction, warrants a robust approach to appellants who fail to obey orders for the payment of a judgment debt and costs when they can afford to pay them either themselves or through others. And again, without wishing to be overcritical, that focus is on, if you like, the CPR, but it does tend to give the impression that one merges to a degree the position of the appellants and the others to whom they have access. Now,
well, it doesn't say they or others can afford to pay them. It does say they can afford to pay them,
yes,
either themselves or through others.
My lord, yes.
Which refers back to 41.3. So it hasn't been proved that they can't get access which is classic MV York territory.
And with respect, my lord, I agree that that is the ratio, but the impression given is the point I wanted to make.
Well, certainly a hair has been set running.
Well, my lord, yes. Now, the only last comment I wanted to make was to the extent that the practicing bar has feelings about these things, it may be that that could be regarded as a form of judicial encouragement. It's a phrase used in a different context, but you know, the bar has a lot of judicial encouragement, and much of it is well merited. And I think, again, I respectfully say that phrase clearly needs to be read in the context of that judicial encouragement. I was going to move next to the Whitman case. That's at tab 18 of the authorities bundle. Page 371, and in MS it is 774.
Yes.
There's been an action under a guarantee. Judgment sum of £400,000 had been awarded, and an application for that to be paid in came on about a month before the appeal, so rather unusual circumstances. At paragraph 7, the learned Lord Justice refers
to the 6 factors, yeah.
Refers to the 6 factors, or says he's been referred to the factors, and one notes that they are described as factors by this stage.
Well, as they are in Hammond.
As they are the second time in Hammond. The first time they're facts.
It's facts, then
facts.
2 paragraphs later it becomes fact.
My lord, indeed.
They were features and now they're factors. Yeah.
I doubt if there's any real distinction between something described as a fact and something described as a fact.
I'm not building my case on it.
Typographical error, as it were.
I'm not building my case on it, my lord. In fact, having referred to those factors, the particular matters before him aren't tied very closely to Hammond Suddard's.
Where do we look next in this?
Paragraph 11. You'll see that there wasn't a stifling argument, so it appears here. The next point made on behalf of the respondent is the appellant has not suggested it cannot pay the judgment debt. That's true, but I fail to see how that's relevant, i.e. that the application doesn't turn on that. That's a point for the respondent to make.
Yes.
And there was a stay of execution, a small point, but one not to lose sight of in this case is, of course, at all material times there was a stay of execution in relation to the judgment against Onur. But I simply plant that just to make sure it's not lost sight of.
Yes.
The most important point for current purposes is probably paragraph 17.
Yes, the nominee litigant.
Nominee litigants.
Yep.
And here, one doesn't know the full background to the submission made, but a very simple answer from the learned Lord Justice. In one sense, any private company owned and controlled by a small number of persons is a nominee litigant, in the sense the fruits of litigation can be expected to inure to the benefit of those persons, but the company nonetheless retains its legal personality, continues to use its assets. The fact there are individuals who stand to benefit if the company is successful and who may themselves exercise considerable informal control is no ground, in my view, for requiring them to fund a payment into court if the appellant itself does not have the means to do so. Now, that point simply wasn't before the court in Hammond Suddard's for consideration, but it's addressed by Lord Justice Morbeck here. He refers back to Hammond Suddard's at paragraph 18.
Yeah, distinguish this on slightly different grounds.
On different grounds, indeed, my lord.
Yep.
So, points to note, we respectfully say in relation to this. First, stifling didn't arise, so the question of proving impecuniousness didn't arise. Secondly, wealthy owners didn't arise in terms, so it's mentioned in the list of factors in Hammond Suddard's. But thirdly, and this is the springboard, if you like, into SocGen, by implication, there is no suggestion that wealth of owners in itself is a relevant factor.
Yes.
I think it seems to me, I do submit, that that's the implied consequence of paragraph 17, which your lordships read. The fact there are individuals who stand behind is irrelevant, and one must read into that regardless of their means.
Yes.
And I'd also mention here, although the focus of my submissions is plainly on owners, because that's the factual situation, a similar comment would apply in relation to funders.
Yeah.
So moving from there to SocGen, You've already seen the key passages. It's tab 15 in the authorities volume.
When you say it's irrelevant by itself. But if the court had to make a judgment whether the corporation could fund the payment, the willingness of those persons to fund would be relevant.
Yes, if I expressed that wrongly, I apologise. Of itself, it is not relevant. I'm obliged. So it's at tab 15. I'll just need to put the passages you've seen already in context, and there are some important features here. In paragraph 1, you'll see that both Mr. Al-Sanair and Saad were appellants. And in fact, they both owed the same sum. So the first set of applications, this third sentence, are conditions be imposed on the two appellants' right to proceed with the appeals. In each case, the conditions sought that A, the appellants pay the amount of the judgment awarded by Mr. Justice Tier, namely circa $50 million plus interest, and then B, the appellants pay the interim costs awarded by Mr. Justice Tier. Now, the reason for that is that there was a primary liability and then a guarantor liability for Mr. Al-Sanair.
Yes.
The next thing, I'll add this comment, both appellants, therefore, in opposing SocGen's application, needed to set out means if they were relying on stifling, which they were seeking to. So if one goes to paragraph 32 next, you'll see here that their lordships had a passage headed "The General Principles Relating to the Imposition of Conditions." So one can see, and again, it's the normal course in the way the law develops, that the Hammond-Saddard's case has become the fount of the principles that are applied. That's pretty much set out or summarised as one's seen before, but you'll note about just over halfway down the page, there's the reference to Whitman has been brought in. Therefore, this appears, and this is point number 5, this appears to be another factor to consider when deciding whether there are compelling reasons to order a condition. I note that Lord Justice Moore-Bick so treated it in Whitman point 5, though he regarded this as a factor on which much caution should be exercised. It seems to me that must be understood as a compressed summary, because you've seen what Lord Justice Moore-Bick said. I couldn't, for instance, find the words "much caution" used in Lord Justice Moore-Bick, but that was their impression. Perhaps that's how it's best put as to how Whitman should be read. There's also reference to the fact the court had noted and adopted, in respect of security for costs, the statements of Curie developments.
Yes.
And then the next thing I wanted to take you to was paragraph 44, page 324, MS 727. Without going into the great details, towards the bottom of the page, the frozen assets in Saudi Arabia of Mr. Al-Sanair, we are told, subject to no exceptions. I'm not satisfied that Mr. Al-Sanair has put forward full and frank evidence to his means.
Yes.
I therefore approach the application for the imposition of conditions and security from the standpoint that Mr. Al-Sanair has considerable available assets outside Saudi Arabia, which would easily enable him to fund the order for security for costs sought, would also enable him to fulfil a condition as to bringing some, if not all, of the outstanding judgment debt into court, etc. Then at 46, you'll see that the Hammond-Saddard's decision, the list that we've already seen, is effectively used as a checklist of factors.
Yes.
And then we've read 54 and 55.
Yes.
But again, it is worth remembering in this wider context that these factors are being looked at in respect of both the appellants.
Yes.
They're both before the court. And my learned friend has made the point in his written case that Lord Justice Aiken strayed away from the correct question in his citation. Fifth factor, does Sard have wealthy owners, and was there evidence they could not, if minded to do so, pay the judgment debt on behalf of the judgment debtor corporate entity? I'd respectfully say that all he's seeking to do is paraphrase the words which you've seen in the Hammond-Suddard's decision.
There's a limit to how far we're going to be helped by a close analysis of what's said in decisions not binding on us, isn't there?
My Lord, yes. I'm, if you like, using this as in part a springboard for the submission that there is a concern that the Court of Appeal has gone down a wrong road, and that feels...
Thank you. Fair enough.
I can develop that further, but that's the background to dealing with the points in this way.
So that is 54 is a paraphrase, you say, of 41.4 of Hammond-Suddard.
We say that's a precise paraphrase. It's intended to be a paraphrase of what was said by the court in the Hammond-Suddard's decision.
Yep.
And of course, as you've seen quoted, but perhaps it makes more sense now in the context of the full decision, when it says the position of Mr. Al-Sanea is parasitic on the company, it really is genuinely parasitic on the company because his guarantee liability is exactly the same, give or take a few minor sums. And then ultimately at paragraph 60, what you will see is that the last few sentences, I have concluded that they should jointly and severally be ordered to pay into court the sum of US dollars 5 million in total. So there, in fact, is no clear distinction when it gets to the ratio of the case as to what money is whose. They're both liable for the same sum. The factors are considered overall in relation to the two of them, and a single sum, because he disbelieved what was said about the means of both of them. He said, I'm not satisfied either that the company is without means outside Saudi Arabia or that Mr. Al-Sanea is without means outside Saudi Arabia, is then the background to the totality of his overall decision reached in paragraph 60.
Yep.
So specific points to note from that, we respectfully say, is first, there was no real scope in this case for the ability of the relevant third party to say no to arise as a matter of the decision, because in fact Mr. Al-Sanea wasn't really a third party at all. He was one of the appellants.
Yes.
He was directly subject to an obligation to give details of his means if he claimed to be impecunious, and there had been evidence put forward as to his great wealth.
Yes.
I've mentioned, secondly, the joint and several order,
Yes.
and that's in any event justifiable on the basis that Saad and Mr. Al-Sanea hadn't given full disclosure of assets outside Saudi Arabia. Thirdly, we say that the Court of Appeal recognises real concerns as to the phrasing of the test, if I can call it that, in Hammond-Suddard's as to wealthy owners, but then said because of Hammond-Suddard's we can take it into account, and we respectfully say that becomes a slightly circular exercise. Because it's not something, we respectfully say, that needed to be analysed in detail in Hammond-Suddard's for the reason given, namely that Hammond-Suddard's could be decided based on the first point, namely that the company hadn't proved it was unable. And we respectfully say that in terms of the way paragraph 55 was articulated, so looking specifically about the wealthy owners question, properly speaking, the exceptional circumstances come down to the fact that Mr. Al-Sanea was a co-defendant with what were assumed to be substantial assets, and in the overall position, he becomes jointly and severally liable. So we say that to a degree, the court's unnecessarily put itself in the straitjacket here of using Hammond-Suddard's as a checklist on this point.
Yeah. Yes.
So you're saying the decision's okay on the facts, but some of the reasoning is suspect.
My Lord, suspect obviously is a word I perhaps wouldn't use, but what I'd say is this. It's a decision which one can see how they reached in the facts, and its ratio is explicable for the reasons I've given, but I do express the concerns I have about the analysis in 55.
Thank you.
Albeit, as you've seen, I do respectfully adopt the concerns that have been expressed in paragraph 54.
Yes.
Now, I wanted to move on from there to the point about separate corporate personality, which I want to take very briefly.
Yes.
The Salomon case is almost too well known to need citation, but occasionally it is worth looking at. It's at Authorities Volume 14, which is MS 678.
Tab 14, yeah.
14, I apologise. And it's worth remembering, of course, that this was a decision which was on appeal from the Court of Appeal, and the experienced judge, Mr. Justice Vaughan Williams, and both those tribunals had held that what Mr. Salomon had done had been an abuse.
Yes.
And if your lordships perhaps cast your eye across the head notes, so
Yes.
this was the nearest you could get to a one-man company
Yep.
In the 19th century legislation. 7 shareholders, 6 shareholders holding 1 share each, and Mr. Aaron Solomon owning the remainder of the shares.
Yes.
Also, as a result of putting his business into the company, he'd obtained £10,000 worth of debentures. And when the company failed, which did not long afterwards, there were unsecured creditors, and he stood in advance of the unsecured creditors.
Yep.
And if one looks at page 279, which is MS 682, you'll see that the Court of Appeal, and it's a strong Court of Appeal, if I can respectfully say that, were of the opinion the formation of the company, this is 2/3 of the way down the page, an agreement of August 92 and the issue of the debentures
It was a scheme.
was a mere scheme.
Yep. So they pierced the veil, effectively.
My lord, yes.
And the House of Lords held that was wrong.
Yes, and there's a particular passage I wanted to draw your attention to, because I've referred to it in our written case, at page 305, which is MS 708.
Yep.
There are 2 paragraphs there.
2 paragraphs in the middle of the page.
There are 2 paragraphs in the middle of the
Would
page.
you like us to read them?
My lord, yes.
We'll do that. So effectively, absent fraud or dishonesty, which he deals with in the next final few lines of the page, you respect the company as a separate corporate personality.
My lord, your lordship has the point.
Yep, very well.
And that's in the case where it is striking, if you like, that if there's any situation where an appeal to the reality ought to work, it's in the case of the one-man company.
Yep.
And that's why Solomon is the most powerful case still after all this time. It's the one that, dare I say, had offended the concerns of the Court of Appeal and an experienced first instance judge, but nevertheless that was the consequence.
Yes. Thank you.
And I do say in this context that it is worth bearing in mind that the basis on which Lord Justice Patten decided was that there was a more than usually close relationship between Mr. Begana and Onur. Onur is a big company. It's had difficulties over recent years leading up to January 2016, but it's a big company. Mr. Aaron Solomon's business was a family business, I believe in the East End, and it was much, much easier to say, and I do suggest one would have said, that he has the closest possible relationship to his corporate vehicle.
Understand.
Now, in view of the fact the principles aren't in contention between myself and my friend, I don't want to go through VTB impressed other than to commend what I've said in my written case to your lordships.
Well, Press was another case of very close relationship, indeed, arguably even closer.
My lord,
In
yes.
this case, you would say, between the owner of the company, owner of the shares in the company, and the company.
My lord, yes. And again, I don't want to read them out, but I've made points at 41 at paragraph of our case about, if you like, the analogy being strong in these sort of circumstances. And one has, in effect, an order made against a company on the basis of something which the company doesn't control, namely what somebody independent of it chooses to do or not to do. In this case, and I characterise slightly, what has happened is a third party, a connected third party, but not as close as Mr. Aaron Solomon, has said no, and the court has said, I can and shall ignore it for this purpose. And that's in a nutshell, we say what it comes down to. And we say that's to treat the third party's assets as equivalent of actually available to the company for the purposes of assessing the company's financial position. And again, to use the phrase in Hammond Saddard's, it puts the owner to election.
If the owner of the company says, I am very reluctant indeed to come up with the money, if it's made a condition, I will do so.
Well, if you like, that in part was the position they had in mind in Hammond Saddard's.
No, I'm asking you what your submission is, never mind what happened in other cases. We're not bound by it. What's your submission?
My submission, if the owner says he's very reluctant, in the normal case under 52.9, that is looking prospectively at the imposition, and the court will take that into account as a factor.
No, what I'm saying is he's very reluctant, but if it's made a condition, he would do so.
Well, in which case he hasn't refused to provide, my lord.
You would say it should be treated as available?
If he's used that form of words, yes.
Well, that's
Because if the court, in cases like MV York, is required to assess whether or not the litigant can come up with the funds, if the person backing the company says, I don't want to, but if you do it, I will, then the court gets the answer.
Well, with respect, yes, and I apologise, I was slow in answering that, but yes, the answer must be
That
yes.
seems to me to follow from the way you're putting your case. I just wanted to make sure, thank you. It's always dangerous, I know, to answer a question too quickly on your feet. I understand that.
Well, I haven't gone further. I'll deal with it after the short adjournment, which is obviously the advocate's last refuge in those circumstances.
But it means you'll be going after the short adjournment, which you won't be, I hope.
I'd better say it'll be well past my time limit as well. The only other point I want to make here is that it's been suggested by my learned friend that it is fanciful to suggest that the Court of Appeal could have lost sight of the principle of separate corporate personality. Now, we respectfully say that slightly misstates what our case is about. I don't know whether it needs to deal with that. The Court of Appeal is busy. It deals with different situation. It deals with the facts and the submissions made to it.
It's difficult enough sometimes to decide whether the Court of Appeal is right or wrong. To decide what was going on in their minds is really not, it seems to be, a particularly helpful exercise.
I shan't pursue it further, but I just mentioned that, given it was raised by my learned friend. I was next going to turn to the Atlas Maritime section of my written case.
Very well.
And this was, if you like, looking behind the company for some other legal purpose. I'll just give you the reference again, because I don't propose to go through it in detail. It is tab 5A60, which is MS66.
Thank you. Yes.
What we were seeking to do here was really look at some examples of when one might be looking...
You say
Tab 5. I don't think
Case. Yes.
Yes, our case.
your case, I'm
Tab
sorry.
5, yeah.
Yes, very well. Tab 2.
I'll try and...
Yes.
Yeah, that's all right. Yep.
Yes, very well.
I'll try and say written case to make sure it's clear.
Paragraph 60, yep.
Paragraph 60.
60.
And so that's
Sorry, I couldn't hear any of that. What are we looking at and where?
Well, I was simply drawing attention to where my submissions are found, and I don't propose to go through them orally.
Sorry, this is paragraph 60 of what?
Oh, I apologise. If I said
It's not paragraph 60.
it's page
A60.
A60.
Case, which is
Is that
Like
page
somebody who was
15?
speaking.
paragraph 42 onwards.
Yes, it's page 15 of your case.
So
Atlas Maritime, paragraph 43.
Yep.
Yes, I see that.
my lord, I'll try and speak more loudly, and B, I'll make sure I
Don't
get
worry.
more
Yep,
accurate
yep,
in
yep.
my
Yep.
reading of my notes.
But really, you don't want to add to what you've said here about it.
Not really, my lord. These were simply examples,
Quite.
and we were explaining how the Atlas case, which is referred to in various of the cases on corporate personality, gives certain examples, but they're a long way from what we have here. So to the extent there might be a spectrum of, as it were, nearness to and distance from Solomon-type points, we say we're much closer to the Solomon concerns in the matter before your lordship.
Yeah.
So that's as much as I wanted to say in relation to those.
Thank you.
And I was next going to move on to my learned friend's MV York case.
Yes, indeed.
Now, this is in Authorities Volume Tab 10, which is MS 532. This case has assumed great importance in my learned friend's written case. It is important to note, we would respectfully say, that it wasn't raised in the Court of Appeal or any of the documentation prior to receiving the written case a month ago. I'm not complaining about that. But it is worth remembering that in terms of how 52.9 discretions are exercised, when one looks at the cases one's looked at so far, it's not looking back to MV York, or at least not directly.
Yes.
So I say that by way of context rather than certainly no criticism of my learned friend about that.
Yes.
We did submit, though, that in our case, and I don't ask you to turn it up, that it is unwise to attempt any overarching theory of what can be looked at in the context of any particular discretion, and we will submit that it will always depend on the particular purpose which is in view. Now, first of all, I wanted to go through the background to York. Your lordships, I suspect, will be familiar with it. This was a case concerning conditional leave to defend under Order 14. It's a language which has disappeared under the CPR. But the plaintiff had sought summary judgment. The master had given unconditional leave to defend. There was then an appeal to the judge in chambers, which was the procedure in those days. That was a new exercise of discretion by the judge in chambers. And he ordered a £12,000 payment in as a condition. That was the condition of leave to defend. And the only evidence before him as to the defendant's impecuniosity was that legal aid had been granted. And as was pointed out, the fact that legal aid had been granted didn't demonstrate impecuniosity of itself, because the Legal Aid Board didn't take account of a house you might own, and a house could obviously be the basis on which you might be able to obtain security. The matter was appealed to the Court of Appeal, and that would be a true appeal, and the amount ordered by way of condition for leave to defend was reduced to £3,000, and that was on the basis of admission of new evidence that, in fact, the defendant didn't own a house. And the key passage is at page 134 in the Authorities Volume Bundling, which is 537 MS.
Yes.
Bottom of the page. The fact that a man has no capital of his own does not mean that he cannot raise any capital. He may have friends, he may have business associates, he may have relatives, all of whom can help him in his hour of need. And all that Mr. Edwards himself had sworn was, I do not have £12,000, nor is there any likelihood of my raising that or any similar sum. And Lord Diplock says, my emphasis. I can see no reason why the Court of Appeal should not be entitled to infer that. Although it might be difficult, it would not be impossible for Mr. Edwards to find security if his defence were put forward in good faith. Now, the
Well, that's that then.
the point in relation to this is that one's got to bear in mind what the law was in relation to Order 14 at the time. We respectfully say that the imposition here of the condition is to protect a plaintiff from the consequences of a dishonest or sham defence, or the possibility of a sham defence. You only get there because the defendant's case is shadowy, and that's a matter that's specifically referred to in the decision, that the Court of Appeal had said it was a shadowy defence. Now, it's in that context that we had produced, which I hope is on your Lordship's desks, the field rank case. It's the very short case I mentioned.
Yep.
And this gives a fuller quote from the Supreme Court practice to the one that was given in York on page 450. This was a leave to defend case some years earlier, where leave to defend is sought, this is the head note, under RSC Order 14 Rule 6. There is now a tendency to relax the strict rule in Jacobs and Booths, that where the defendant could show by affidavit there was a bona fide tribal issue, unconditional leave to defend should be allowed, and to impose as a condition of granting leave payment into court or giving of security where there was evidence for believing that the defence set up was a sham defence. And if one looks through to what Lord Justice Devlin said, and this is a case that continued to be cited in the White Book for many years, if you look middle of 1288, he refers to the broad principle, first of all, and what the annual practice said about it. The principle on which the court acts is that where the defendant can show by affidavit there is a bona fide tribal issue, he is to be allowed to defend as to that issue without condition. If that principle was mandatory, then the concession by Mr. Phillips, had been conceded by counsel, that there's a tribal issue would mean at once that the appeal ought to be allowed. But then Mr. Phillips had drawn attention to other conditions and also a previous case in which Baron Bramwell had said, and this is the top of page 1289, that conditions of bringing money into court or giving security should only be applied where there is something suspicious in the defendant's mode of presenting his case. And then he says, for my part, I should be very glad to see some relaxation of the strict rule in Jacobs and Booths. Goes on, although he cannot say for certain there's not a tribal issue, he is nevertheless left with a real doubt about the defendant's good faith and would like to protect the plaintiff, especially if there is no grave hardship on the defendant being made to pay money into court. For my part, I should be prepared to accept that there's been...
Why are we reading this?
My Lord?
Why are we reading this?
My Lord, it's the context to what's meant, what the importance was of shadowy in the reference in York, and also that when one looks at the passage quoted very shortly in the last paragraph of Lord Diplock, the condition of payment in a court or giving security is nowadays more often imposed than formerly, it's to give the context that it is still the case at the time of York that the shadowy element is the necessary.
Yeah, but I'm not sure how that goes to the principle in this case. I understand that you would say in York Motors, on your case, that the courts below, upheld by the House of Lords, were merely saying that they were not persuaded that he couldn't find the money. I'm not quite sure how, why we need to dig deeper into the case on your argument.
I've tried to deal with it in that very brief way, just by reference to a short decision, in order not to labour your lordships any more than necessary.
You're
with
a
the
bit
authority.
worried about the Lord Justice Brandon quote, and you want to put it in context, namely that this is in the context of shadowy defences.
That's the only intention, my Lord. Yes, I respectfully adopt that.
But I mean, does Lord Justice Brandon's quote cause you difficulty in this case anyway?
Well, what I was going to say was that there are...
Because I mean, you're having to look to the likelihood of the person against whom the order is being made obtaining funds from friends and so on. And if the evidence is that he or it will not,
Well, my lord, your lordship has anticipated the point I was trying to get to next, which is namely this. There are two strands, arguably, here, which aren't really drawn out. This case doesn't assist us on what happens if the third parties say no. There's an element, at least, of whether the third party would say yes is seemingly a litmus test in York of whether the defence has bona fides. And I won't read the passage again, but if his defence were put forward in good faith are the key words. But also there's the question of the position would have been different if the defendant had said he couldn't get the money. And that also wasn't the case because, as Lord Diplock has emphasised, likelihood of raising £12,000 or any similar sum.
Have that point, yeah.
So that's what I wanted to say there. The case doesn't ultimately assist on the questions before your lordship when you look into it in that level of detail.
Yep.
And we do respectfully say that it arises in a specific context, namely how Order 14
Yes.
and leave to defend worked. The position we say comes to this. There are potential analogies that can be drawn between different rules in the CPR. And I would make this, which I hope is more than a purely forensic point, if it were the case that it was simply the same discretion, all one would need, or one could hope could be engineered, is a single rule, somewhere in Rule 3 in relation to conditions. And in fact, my learned friend has referred to a case called Huscroft. That was a case, and my friend will develop this if necessary, which said that you can't use Part 3 if you're applying it, for instance, like Part 24, without applying the Part 24 principles.
Yes.
You can't use Part 3 to get around the separate lines of authority that exist in relation to different discretions. That's our submission, at least, as to what's to be drawn from it. I wanted to address Keary very briefly. Again, it's a short point because it's really developing what I've said already. Keary is found at tab 9 in the authorities volume. This is a case under section 726 of the Companies Act 1985, and now that's all been folded into the CPR nowadays, but security for costs against a plaintiff company. There was a dispute arising out of a joint venture agreement, and the plaintiff was a small company. The defendant was Tarmac, which is an extremely large company. The stifling test, just by way of context, is referred to, if you look at page 123.
Which tab are we on?
This is tab 9 of the authorities volume,
Thank you.
and as I say, starts at MS 520. Within that, page 123, which is MS 526, point numbered 6, which is letter G, before the court refuses to order security on the ground that it would unfairly stifle a valid claim, so ex hypothesi in this context, it's a valid claim, the court must be satisfied that in all the circumstances it's probable that the claim would be stifled. So again, without getting into the detail of different tests, if the overall question is probability of stifling, that's different to what was being looked at in Order 14, where you start with a great concern about whether this is a meritorious claim at all.
You saying that's the wrong test or the right?
No, I'm simply addressing, based on what we've got here, that one's looking in these different strands of authority at different contexts. A small point is that top of page 124, there's mention of MV York being analogous. And again, we don't disagree with that, but that is the word to use, and to remember that it means something rather than simply an alternative expression for is exactly applicable. The next point is that Yes, again, it doesn't begin to address the issues in SocGen about paragraphs 54 and 55, namely what about the position of the third party, and certainly doesn't get into who says no.
Yes.
So that's all I wanted to say on Kiri, that ultimately it doesn't assist your lordships any further on the questions on this appeal.
Thank you.
So my next heading, very briefly, and if there's an element of repetition, I apologise, so I'll run through this very fast. These are simply summary points of principle which we say should apply in this context. First, it's common ground, a condition shouldn't be imposed which is incapable of fulfilment. Secondly, it's common ground that where a party, corporate or individual, claims the imposition of a condition of any sort would stifle, it's a burden on him or it to prove that. Thirdly, we accept the investigation is not required to stop with that party. Plainly, it goes further. The question is what is available to the litigant, but it is important to note, as the corollary of that, the test is what can be raised from third parties, not whether those third parties are wealthy. The next point is we say that the search for an umbrella approach to financial conditions, as suggested by Goldtrail, should be avoided. There's the practical reason in this context that your lordships don't have anything like the detail of all the ranges of discretions under the CPR that your lordships would wish. But secondly, for the reasons given, even on the examples you've got, you can see that different factors potentially come into play. Next, we respectfully adopt what was said in paragraph 54 of SocGen, which I won't repeat, namely, repeat in detail, namely there's a good reason for a distinction in principle between security for costs and payment into the judgment sum.
Yep.
And we say for those reasons, on the existing state of the law as regarding taking into account the wealth of third parties in the Court of Appeal, the bar is set too low by the combined effect of Hammond, Saddard's, SocGen, at least as they have been understood.
Right.
And we do respectfully say that if one is looking for a litmus test, in circumstances where somebody has said no and they're entitled to say no, is that the court should be looking for some form of abuse. Now, I'm looking primarily at owners, and I'll come very quickly to a position of Mr.
When you say the person says no, I mean, should one take this at face value? Shouldn't one be looking at the history? Well, shouldn't one be looking at the extraordinary way in which Mr. Bagana has been making subventions to keep Onur afloat? So, I mean, are we to be blinded by an inevitable reaction? I'm not going to pay.
My lord, no, but the answer is what you do is you test what has been done and ask yourself, in the cold light of day, dare say, whether there has been an abuse in what has been done or whether somebody has done what they're perfectly entitled to do in accordance with the law. There is no suggestion in this case that Mr. Bagana was not entitled to take out the dividends, for instance, at the time he took out dividends.
It seems to me you can say that on that point you've been asked about, that Lord Justice Patton has said it seems clear to me that Mr. Bagana has decided not to fund the payment by the company, paragraph 25. That's what he seems to have concluded.
Yes, and I'm not challenging that.
No, you're not. Of course you're not.
You don't want to challenge it, because I mean, if Lord Justice Patton says Mr. Bagana does not has said he won't, and then doesn't go on to say I don't believe him, then on your approach that's fatal to the award of the.
That is the logic of my position, my lord. Yes. I've already made the point about Solomon, but I do respectfully say that if there was ever a more than usually close relationship, it was Solomon. Don't propose to go over that again. I would simply draw to your lordship's attention, commend to your lordships, the passages raised at paragraphs 12 and 55 to 56 of our written case, which set out the reasons why, although some concerns, as my Lord Wilson has said, may be there, from the point of view of somebody not looking at it from the strict legal position, the legal position is Mr. Bagana has done nothing wrong. There's nothing abusive in what he's done.
I mean, we have this frequently in the family division, Mr. Gibbon. We have a history whereby the father of a husband has been making gifts, regular gifts to the husband, which has kept the matrimonial home afloat. Then there's a divorce. So the question is, should the wife get maintenance? And the husband conventionally says, well, my father has no obligation to pay me these sums, so I have no money. And the family division says we must look at it realistically. There's been this long history of payments. And we hear what's said. Inevitably, the father-in-law is saying, I'm not going to continue to pay. But we look at it quizzically, Mr. Gibbon. Yeah, are we looking at it wrongly?
I'm going to express no views at all on family law, and I'm not suggesting that in the family law context that is the inappropriate approach. What I'm suggesting, though, is in this context, for the reasons we've given, the quizzical approach should demand an abuse before it intervenes in the way might.
Well, there are two separate points, aren't there, which we mustn't confuse. One is whether there's an abuse, which is a quite separate point. The other point is whether, as a matter of fact, the court concludes that the money said to be capable of being forthcoming from a third party will be forthcoming.
My Lord, indeed, they are entirely separate points, I agree. Now, the difficulty we have here, and it wouldn't ordinarily arise under 52.9, and I've mentioned this earlier, is 52.9, the imposition of the Condition Acts prospectively, so there would be a period. So if somebody had expressed a view that the court thought was equivocal about I might or I might not do, then if he is to be put to an election, he has a real election. It's brought into sharp focus by our situation because that doesn't arise here. You decide it in limine, in effect, at this stage. But as I say, I don't want to stray into the question of the change of circumstances, etc., which aren't before your lordships today.
Yes, I see. Yep.
My Lord, unless there's anything further, those are the submissions I wanted to make.
Thank you very much indeed, Mr. Gibbon. Ms. Eilert? Mr. Miles?
It's possible that there's not actually a great deal between the parties on the principles, having heard now learned friends' submissions.
We're into a New York situation, are we?
It appears that it comes down largely to a question of fact, because they accept that, they appear to accept that it's not enough for the person to say, I'm not going to pay. That's a Mandy Rice-Davis point. The owner is always going to say, oh, well, I'm not going to pay. It would completely neuter the ability of the courts to take an MV Motors kind of approach and look at the reality of the situation. The owner will always say, if you accept their argument in this case, oh, I'm not going to pay. According to them, that's the end of it. So as long as the chap says, I'm not going to pay.
No, that's not right, Mr. Miles. And if it is right, certainly I don't think it could possibly be right, because if it is what's said, it couldn't possibly be right. The court must form its own view. It isn't bound.
Yes, of course. That's our submission. Of course, the court's not bound by someone saying that. That would be an impossible position. So the court has to look at the reality of the situation, all of the evidence, including the evidence about the relationship between the owners and the company, the extent to which the owner has agreed to support the company in the past, the subventions that have been made. You've seen the summary of the evidence in Lord Justice Patton's judgment. You also then see what the owner in this case actually said about his position. And all the evidence there is on this point is the passage which is summarised or set out in paragraph 23 of Lord Justice Patton's judgment, which was referred to earlier on today. That's on page A95.
Yep.
So the owner says, you don't get direct evidence from him, it's given through an intermediary. And it's quite interesting evidence because he says he's made it clear that he would only contemplate considering the possibility of advancing further amounts to owner heir in the most exceptional circumstances if there were commercial payments strictly and immediately necessary to keep owner heir in business due to the already significant indebtedness of the company to him and the deteriorating financial condition of the company. And then he says that he doesn't then go on and say, if you read the next passage, that he will not make this payment. No. What he says is that he would consider it to be a breach of the human rights legislation, a point which is not being pursued. He doesn't actually say, I will not pay.
What about...
And then in 25, just coming on to that, which I think, sorry, am I anticipating the question?
You're ahead of me.
What the judge is saying in that passage, read properly, is he has chosen so far not to pay. He's not saying he will not pay if push comes to shove. Now, push has not come to shove in this case because they managed, through a series of rather, I would suggest, remarkable applications to the court for extensions of time, which they then didn't pursue and so on, to spin this out for ages and ages. They managed to get away, I would suggest, with keeping this case just about alive. And what Lord Justice Patten is saying in that passage is, he's chosen so far not to pay this debt.
Well, that ties in with the last sentence, does it?
Yes, because you've got to see what Lord Justice Patten thinks he's doing, what exercise he thinks he's undertaking. In paragraph 20, so 25, the last sentence of that only makes sense if Lord Justice Patten is saying, Begana has chosen so far not to pay, but if push comes to shove, I'm not satisfied that he won't pay.
Does he spell that out?
Well, he doesn't say that in terms, but I would suggest...
Whereas that is the critical point, isn't it?
He doesn't say it in terms.
No, but it is the critical point.
I agree. But it's clear that that must be what he means, because...
I wonder if it is so clear. I mean, read the sentence. It seems clear to me that Mr. Begana has decided not to fund the payment by the company, and if I can take his financial position into account, it's not saying on what basis he can take the financial position into account. In assessing the ability to pay, then the CPR 3.1.7 application to vary cannot succeed.
But it must be, you've got to read that with respect together with 26, which is where he explains what he thinks this is about. If you look at the last bit of 26, the last sentence of 26, because the point about corporate personality was raised.
He talks about but he talks about, in the sixth line, he talks about the ability of third pump, not the preparedness.
But it then goes on to say, if I can just go on to the last bit of 26, there is, I think, an obvious distinction between whether a third party can be said to be under any sort of obligation as a result of an order made against a company, and whether, in considering the likelihood of a company being able to make a potential payment, its access to third-party funding should be taken into account. Now, that can only mean by way of an advance or equity injection or whatever it may be. Its access, not the third party's own funds. It's saying its access to third-party funding.
Well, that could mean one of two things, couldn't it? I mean, its access in the sense that it would be possible, and its access in the sense that it is more likely than not to happen.
Because I think it's very important to see in the third sentence of paragraph 26, he says, it is clear as a matter of authority that the ability, i.e. the ability of third parties to fund the company may be relevant. And the matter of authority to which he then refers is the Société Générale.
Yes, but...
which does not take the MV York approach as to the probability of whether the entity will obtain funds.
Well, with respect to that case, as Mr. Gibbon was quite careful to say, and I would respectfully suggest it's right, one's got to be careful not to get caught up too closely in the way that these various factors, which have been looked at in the Court of Appeal cases, are then trotted out as if they're some part of the actual test. I'd suggest that what Lord Justice Patten understood himself to be doing quite clearly from paragraph 26 is determining whether the company has access to third-party funding. That's what he says he's doing at the end of paragraph 26. It's the test he's set for himself. He is not saying, he's not collapsing the two things. He is not jumping from the wealth of the third party and saying that is the test. He is asking himself the right question: does the company have access to third-party funding?
Well, but what about paragraph 28? He doesn't seem to think that's a test. He seems to think it's an exceptional circumstances test.
Well, that, with respect, is because he thinks that he's bound by what's said in the SocGen case.
Yes.
And we suggest that the SocGen case has gone a bit wrong on this by introducing a test of exceptional circumstances.
But that is the difficulty. It may well be if he'd applied his mind to the question, he might have concluded, Mr. Begana says this, but I don't believe him. But what he has done in paragraph 25 is he says, Mr. Begana has said no. If I can take his position into account, though, then Onur fails. He then goes on to say, it's clear as a matter of authority, I can take account the ability of the third party to pay. Yes, and then he cites for that SocGen and confirms the test as exceptional circumstances in 28.
I accept that, but on the other hand, you've got to ask yourself, what is he saying at the end of paragraph 26, which I would suggest is the key passage in telling you what he thinks the test is.
But why say what he says at the end of 25? Why quote SocGen at all?
Well, because he considered himself to have to deal with those cases naturally as a judge of the Court of Appeal. But in 26, I suggest that he's asking himself the right question. And it is very important, that last bit. It's the access of the company to third-party funding. He is not short-circuiting things. He is not bypassing the company and just looking at the position of the shareholder. He's looking at the access that the company has to third-party funding. Now, if I can go back to what's said in 25, as I say, what he must be saying is he has decided to date not to pay this sum into court, but he is not, I suggest, accepting that if push comes to shove, he will not pay the money in. It must be part of, in other words, he will lend the money to the company because that's the only way it can happen. He clearly doesn't think that he is making an order against Begana himself. He clearly doesn't think that he could do that. He's making an order against the company, or he's upholding an order which has already been made as against the company. And it's for that reason that he says at 29, where he actually gives his conclusion, Onur has not established that it could not have satisfied the condition. He understands that it's for the company to establish that and satisfy the court with evidence that it cannot do it. He understands that that involves looking not only at its own resources, but at resources that it can raise. And he comes to the conclusion that he's not satisfied that it's discharged that burden. And I suggest that it's just unreal to read him as coming to the conclusion that all that needed to be shown was that Begana was wealthy.
No, he doesn't say that, but he says in 28 that there are exceptional circumstances. And you develop on a case-by-case basis, controlling shareholder, chairman, largest creditor with security for loans, an unusually close relationship. I can't distinguish it from Société Générale. So the reason he is saying that Onur can do it is because he believes he is tied by authority to the view that the ability of the third party with a close relationship to fund is sufficient.
But it doesn't make sense with respect. That is to attribute that mode of reasoning to Lord Justice Patten with respect is unreal, because what is the mechanism by which the order would then be made? He's got to, it's implicit in everything that he says that he thinks that if the order is made, Begana will put up the money. It's implicit.
Isn't it?
He's not making an order against Begana. He can't.
It's such a fundamental point that it is remarkable that the only express reference to Begana paying is a finding that he has decided not to fund.
To date, if you read that as meaning...
Well, you say to date.
Yeah.
Maybe, but it's the only finding. There's no finding that I think he might change his mind or will change
But it must be, with respect, my lord, it must be part of his reasoning. Because
if you're right as to how he arrived at it, but the end of paragraph 20, since we're going around the houses, but the end of paragraph 26, it does seem as if he's saying that I can equate Mr. Begana with the company. And it's all a question of what access means. I mean,
well,
it could mean, you're absolutely right, it could mean access which will achieve something or potential.
but he's dealing
You
with...
say it makes no sense unless he
includes what I say. It just makes no sense.
Justice Patton has been playing the game long enough. He knows perfectly.
Of course he
The question
does.
is what would happen.
And bear in mind as well in 26, with respect, my lord, bear in mind where this starts in 26. The argument in 26, which he's addressing, is exactly the point that he's blurring the shareholders with the company. In other words, that he's infringing the corporate personality principle. That's exactly the argument that he's meeting in that paragraph. So
Well,
it can't be the case that he then thinks, oh, well, I can ignore the different personalities. He's clearly thinking, look,
No, but that's not
the
right.
company will get access because Begana will advance the money.
The first two sentences are Mr. Gibbons' submission. Then he comes to but. It is clear as a matter of authority the ability of third parties to fund the company. What's the authority? And it must be, must it not, SocGen?
But but SocGen isn't. SocGen itself is not saying that we'll look at SocGen in a minute, but SocGen itself is not saying that you ignore the separate personality of the companies. It's not a case where the corporate veil is ignored or anything of that kind. It's actually a case where in the end, you'll remember that the judgment debt was 50 million. In the end, what the court ordered was that they put up 5 million. Now, again, I suggest that in the SocGen case, the reason for that was that they conclude that that's the amount which is realistic for the company to put up. Why? Because that's the amount that it can access from its owner in that case.
But there's no need for any exceptional circumstances test. If all you're doing is doing the equivalent of MV York and saying, well, can the litigant crowdfund his claim, then it is simply a question of whether or not the litigant has satisfied the court that he can't. There's no need for an exceptional circumstance.
I'm not an advocate for the exceptional circumstances test, in fact.
But the reasoning in 27 and 28 is that you have to apply an exceptional circumstances test in order to bring home or bring into account Mr. Begana's resources.
But you can get there without that part of the reasoning.
He thinks that the previous cases require a sort of umbrella reference to exceptional circumstances. So he makes that reference.
Yeah.
But you say that you've got to drill down and see what the actual factors were.
Exactly.
Which were in his mind.
Exactly. And it only makes sense, we say, if he thought that if push came to shove, Begana would put up the money, because where else was it going to come from? The conclusion he reaches is that he is not satisfied that the appeal will be stifled. That is the conclusion.
I mean, your difficulty is that he doesn't spell out.
Yes, I accept that.
Being able to and doing it.
Yes.
Unless it is in the expression, it's access to third-party
Yes.
funding. Because you'd only have access to third-party funding if they're actually going to
do it.
Do it.
Yeah.
And therefore, the only way you can understand the last, one way of putting it at least,
Yeah.
would be the only way you can understand the last few words in paragraph 26 that what he meant, must have meant,
Exactly.
was that the...
And that's
that
exactly...
not only could they be able to produce the money,
Yeah.
but that when push came to shove, as you say, they would.
They would.
Very
And-
odd, he doesn't say so in paragraph 28 when he explains what the exceptional circumstances are.
No, but that's because, as Lord Wilson just said, he felt that he was hidebound by this test of exceptional circumstances, and he sets them out. He doesn't need to repeat the point that's already been made.
But having said in paragraph 25 that he's satisfied, he's clear to him that Mr. Begana's decided not to fund, he then finds, according to you, that he will fund,
Yes.
but goes on to find exceptional circumstances, which he bases the whole decision on.
Yeah.
Nowhere mentions that he actually would fund.
No, but he must... Well, we're going round the
But
horn.
yeah, I mean,
We're just going round in a circle.
I find it quite difficult to understand why we're spending so long analysing this decision. I mean, one can take two different views, and clearly some of the language could have been better. But as a point of principle, which is what presumably we are mainly concerned with, there's no difference between them.
No, well, that's what's so surprising
I mean, you
about
both
this.
agree that some of the language of cases like Salk
Yeah.
and possibly Hammond Sudders needs to be put in a proper context.
Yeah.
But there's no difference between all
And
that.
the way this...
As to what we actually, how we make of
this
Justice
judgment.
Patton's decision is probably, I mean, it's obviously important to you two, but it's
Very.
not particularly important to us.
That's why it's like MV York. When in the end they were just deciding whether to overturn the court on the facts.
Yes, I agree with everything that Lord Conworth has just said, that
Quite.
the real dispute now between us appears to be not one of principle. Now, can we just step back a minute? Because the way this appeal has been brought...
Except the unfortunate reference to exceptional circumstances in...
But they agree that that's not
But
neither of them are defending
I
it.
don't like that.
Yes.
And I'm not seeking to defend it. I think it's come out of... I submit that it's come out of really the process that Mr. Gibbon described, where you get a case like Hammond Suddard's, where the judges set out the facts of that particular case. It then becomes a sort of checklist. In the SocGen case, it's then treated as a checklist. In fact, we suggest that it's been slightly misunderstood and muddled in SocGen, and they end up with this test of exceptional circumstances, which we don't advocate. But the question of the interpretation of this judgment, which we suggest is very important, also does require you to go back and look at paragraph 23 again, and I would just ask you to look at that again, and the oddity of the evidence that was being put forward by Begana. He was not saying, I will never pay this amount of money.
No, I understand that. I understand.
And therefore, when you read what Lord Justice Patton said in 25 and 26, reading it as a whole, we say it's obvious that he was rejecting that. He doesn't say so, unfortunately, but one has to take a sensible reading of decisions, and it's not a semantic exercise. We say that's the clear conclusion that he's reached. But just stepping back, this appeal has been brought on the question of principle. The way it was expressed in the petition for leave in the case, which has been put forward by the appellant, was whether in principle it is appropriate to take into account evidence about the wealth of the owner. And it now appears to be conceded that in some cases it is indeed appropriate to take into account the evidence about the wealth of the owner. In fact, it seems to be accepted that it is always an appropriate thing to take into account if a stifling defence is being run. What you haven't got is all the material which was before Lord Justice Patton. You haven't got the exhibits to the witness statements. You haven't got the accounts. You haven't got because we're not making it, the lengthy argument that was put before him on that day as to why the stifling defence was not made out. That is not the matter which is before this court. This court was asked a question of principle. Yeah. Is it ever appropriate to take into account evidence about the wealth of the owner? And it now, as I say, appears to be accepted that indeed it is. And indeed it goes further than that, because Mr. Gibbon conceded that the court is not bound, even by a statement of a owner saying, I will not pay. It's always then going to be a matter of fact for the court hearing the application whether it accepts that evidence.
Mr. Gibbons' point has never been that you cannot have regard to the wealth of the owner, but what he is saying is the wealth of the owner and the owner's intimate relationship with the company in themselves are not enough. And I don't think that matter is in dispute between you. But there is a clear reading of Société Générale as we conceive in Lord Justice Patton's judgment itself in the fourth line of paragraph 27. One of the issues was whether the appellant company had wealthy owners who could pay. And which ties back to the previous statement in 26. It is clear as a matter of authority that the ability of third parties to fund the company may be relevant.
Yeah, but
I think you're in agreement that in itself it isn't relevant unless you go further and establish a likelihood.
Unless you go further and establish the access to third-party funding referred to by Lord Justice Patton in the last few words of paragraph 26.
Well, I would put it this way. Can I explain how we...
Maybe that's a question of fact.
That's a question of fact as well, but can I just explain...
Remitted to the Court of Appeal, I
don't know. And it's not something which is before this court.
Well, I don't know. If we look at the issues on page A45, where Hammond, Saddard and SocGen wrongly decided, as a matter of principle, when is it relevant for court to take into account the financial position of a third party? And did the learned Lord Justice take into account Mr. Bagana's financial position?
But on the other hand...
That's all within the ambit of...
But the way the case has been put is that this is a question of principle, that you're not being asked to decide whether or not, as a matter of fact, the conclusion that Lord Justice Patton reached was correct.
No, but we are. Did the learned Lord Justice err in taking into account Mr. Bagana's financial position? And we are told, yes, he did by Mr. Gibbon, because the evidence was he wasn't going to pay, therefore it was irrelevant. And I think you'd accept, if that was the finding, Lord Justice Patton did err.
Well, if you look at paragraph 7 of their case, which is what we thought we were dealing with, the hearing fixed for the 27th of April is only for the purpose of considering the question of principle as to the correct approach when exercising that discretion to take the ability of third parties, such as Mr. Bagana, to pay a
correct approach to take to the ability of third parties. And what's said is the correct approach is to take it into account if they're prepared to pay on the balance of probabilities, and not if they're not.
Right. Now,
which is what I think you agree.
Well, I'm not sure with every word of that about the balance of probabilities, etc. Because
what makes you agree?
Now, what we say is the right approach is this, and we say that to some extent what's gone wrong here in the cases arises out of this idea of the idea of taking into account. We suggest that the right approach is this: to have an order under this this particular rule of the CPR. It's necessary to persuade the court that there is some compelling reason for the order. That's what the rule says in terms.
Yeah.
We would say that the wealth of the owners of the company is not an independent factor that would support such an order being made. In other words, you need other reasons which have nothing to do with the wealth of the owner. If the company which is facing this order then says, oh, but my appeal will be stifled, what then happens is that the onus is on that party to persuade the court that the order would stifle the appeal, and it's for that party to bring forward evidence establishing that. And in the context of that exercise, the stifling question, evidence about the wealth of the owner is likely to be relevant. It's not going to be conclusive because evidence about whether the owner will support the company is also relevant. But that's it. It's in the context of a stifling argument that evidence about the wealth of the owner is potentially relevant.
I mean, one of the difficulties at the moment is if one looks, for example, at paragraph 7 of the appellant's case,
Yes.
where they say, which we raised out a moment ago, the hearing fixed and so on, only for the purposes of deciding whether when exercising the discretion, it's right to take account of the ability of third parties,
Yes.
such as Mr. Begana, to pay.
Yeah.
Well, actually, it's common ground that the ability to pay, having the money, is
Potentially relevant.
potentially relevant.
Yeah.
But it's obviously only one factor.
Yeah.
It doesn't answer, or indeed ask, the key question, namely whether he's likely to do so.
Yes.
So however we answer that question will not resolve the issue.
No.
But it's actually the other way around, whether it's been shown that he's not likely to.
Yeah.
Yes. Yeah, and that's the way that Lord Justice Patton.
No, I don't think that's fair. It's a correct approach to take to the ability of third parties. Is it enough that they're able, or do you have to be satisfied they will? I think it's a perfectly fairly worded question.
Well, there it is. I make that submission about
Can I just ask you this?
paragraph 7.
If we were to find that Lord Justice Patton had got it wrong on the law, where do we go from there? We have to send it back to him.
Well, presumably it goes back to him, and you haven't got the material.
No.
We can't decide it.
You can't.
If we think it's unclear, then presumably also you'd say we send it back, if we're not clear whether he applied the right rule.
Well, I think you need to reach a decision, no doubt, on whether you think that the decision is to be read in the way that I have suggested.
If we think it's not clear,
Well, I would suggest that you should make a decision on it.
well, I know, but if we decide contrary to what you're saying, that we think it's unclear, what then?
Well, I suppose it goes back to him.
That's what I rather thought. Now, I quite appreciate you say we should construe it the way you say.
Yeah, and
And normally, it's quite right, we have to reach a view.
yes, I mean, it's just what this court often has to do. And I'm afraid to say that often you're faced with decisions which aren't perfectly worded, and you've just got to work out what the court must have meant. So I would have...
But in effect, you are substantially in agreement that we can bury the reasoning of Société Générale.
Yes.
Yes.
Yeah, I mean, my approach is I would suggest, a fairly simple one.
Yes.
That the proper analysis is that there has to be a proper reason for making this order in the first place.
Yes.
There's then a separate question: would this kind of order stifle the appeal? At which point the burden of persuasion shifts to the resisting party.
Yes.
It's for that party then to persuade the court that the appeal would be stifled, and it's at that point that evidence about the means of the owners and so on comes into play. That approach has, I don't know about whether one's trying to put forward a theory of everything, some unifying theory, but that approach has the merit that it is consistent with the decision of the House of Lords in the MV York case.
It sounds, we haven't heard from this precise formulation from Mr. Gibbon, but at the moment it sounds to me to be a very sensible way of putting it. Maybe he'll slightly want to reword it, but in principle,
that's the
but you end
substance.
up, whoever the onus on, and assuming you're right, it's on the appellant in this case, come back to the question that I think you both ultimately agree. You may formulate it slightly differently, but it's a question of fact where you would emphasise, for obvious reasons, that the court is not bound by the say-so of the alleged funder.
Because otherwise it's...
No, of course.
And
It's really, in your written case, it's clear you see MV York as a useful approach.
Yes.
In this context.
I do.
Yes, and the wealth is relevant if the person arguing stifling is able to persuade the court that not only is he wealthy, but if the order, but if the person trying to argue stifling isn't able to persuade the court both, I got the wrong way around. The person resisting the stifling
No, it would be the person alleging stifling.
The
I
person
suspect.
alleging stifling either shows that he isn't wealthy enough to do it, or shows that he won't do it, or is unlikely.
Well, it's the person, in this context, it's at one remove. So the party which is alleging stifling has to show that he doesn't have his own resources from which he can do it,
Yes.
and that he can't raise the money
Yes.
elsewhere. At that point, if he's running that argument, and the court will expect evidence about this, if he's running that argument, questions about the wealth of those people who are likely to be the class of people who will support him is going to be relevant, inevitably.
Can I ask this? If, contrary to your submission, we think that Lord Justice Patton was applying the approach which Lord Hodge and I have been putting to you, or that it's unclear, do you go so far as to say that on the evidence, at least in the judgment, paragraph 23, the quote in paragraph 23, he could only have come to one conclusion on stifling, that they couldn't have proved it?
Yeah, because if I'm right about burden,
Quite. That's why I wondered.
then all you've got is this very unsatisfactory piece of evidence which is quoted in paragraph 23, because that's all the evidence there was on this point, in which he is not saying, I will not pay. He's saying, he's taking some point about it being an infringement of his human rights.
Understand.
And
He himself has said nothing.
he himself has said nothing, and that is all the evidence. So if I'm right about burden, then we say, well, actually this court could say, well, he must,
Yes, I see.
it must be right.
What do you say, Mr. Miles, about the earlier bit of Ms. Erguven's witness statement, third line? He's made it clear he would only contemplate considering the possibility of advancing further amounts to Onur in the most exceptional circumstances if they were commercial payments strictly and immediately necessary in order to keep Onur in business.
Well, why wouldn't this be such a payment? This is a commercial payment. It arises out of the affairs of Onur, and we say it's one of those payments.
What weight, I'm probably out of date on all this, in certain cases the court takes a pretty dim view of hearsay evidence. In other cases the rules make it clear that hearsay evidence is admissible. In this sort of case, would it be usual for Mr. Begana not to make the statement himself, and if so, was there any explanation about why he wasn't?
The answer to that is that, of course, such evidence is admissible.
Yes.
I would suggest that this is the kind of situation, and I can't suggest there's a real practice on this, but I would submit it's the kind of situation where you would expect this man to provide a witness statement himself. And the fact it's being done in this way does undermine the force and cogency of the evidence. And I understand there was no explanation for why he didn't put in a witness statement himself.
Thank you.
In terms of the test and the question of principle, just going back to that, and
Before we do, is there anything in the judgment about burden of proof?
Don't think so.
I'm not sure that there is, but it's common ground between the parties on this appeal that if a party alleges stifling, the burden is on it to establish that. So that is common ground, and I would suggest that that's clear from authority. And partly from MV York, but partly from another case, which I just want to draw to your attention, which you've already seen, which is in tab 9 of the authorities bundle, which is the Keary case, where on page 123 of the bundle, at paragraph 6, this is in the context of security for costs, but we suggest it's exactly the same principle on stifling. Before the court refuses to order security on the grounds that it would unfairly stifle a valid claim, the court must be satisfied that in all the circumstances it's probable that the claim would be stifled, and then in the next paragraph, however, the court should consider not only whether the plaintiff company can provide security out of its own resources to continue the litigation, but also whether it can raise the amounts needed from its directors, shareholders and other backers or interested persons. And that's really what we say is the right formulation of the test here. And then it goes on to say, and this is the point about burden, as this is likely to be peculiarly within the knowledge of the plaintiff company, it's for the plaintiff to satisfy the court that it would be prevented by an order for security from continuing the litigation. So that's the basis of the burden point, and we say that applies with just as much force here. Now, in the Hammond-Suddard's case, this passage was expressly referred to and adopted. Oh, sorry, I should have said if you go over the page, you'll see that Lord Justice Peter Gibson in that case actually referred to the MV York Motors decision, which is really the root of all of this. So it's just a thread that goes through all of these cases. And then in Hammond-Suddard's, you'll see that that Lord Justice Clark, as he then was, in discussing, there was a security for costs application in that, as well as an application for payment in of the judgment sum. And under the heading of security for costs at 25, and then going on to 27, the Court of Appeal adopted the Kiri developments approach and the passage we've just looked at. And then when dealing with the question of stifling for the purposes of the payment of security for the judgment debt, so the point we're really looking at now, in paragraph 41, 5, a passage which you haven't looked at yet, for the reasons we've already given, we're not persuaded that this appeal will be stifled if we make the order sought. And that's clearly a reference back to the discussion we've just looked at under the heading of security for costs, including the Kiri case. And then in 45, which you were taken to, Lord Justice Clark makes the point that it would be different if it was a Kiri-type case. And he says, if it were able to produce evidence of the kind identified by Lord Justice Peter Gibson in that case, the position might well be different, because it may well be that in that event, justice would require that the appeal be allowed to continue. So we say that what the court was doing in that case was adopting the Kiri approach in the context of the rule which we're looking at, which is payment in of the judgment sum. And we say that is the right approach. The person resisting the order has to show first it doesn't have the resources itself, but secondly it can't raise them, and the burden is on it to establish that.
To be fair to Lord Justice Patton, I think if you look at second sentence of paragraph 29 of his judgment, on page A98, he effectively accepts that the burden is on Onur to show stifling. Onur has not established that he could not have satisfied the condition by some later point, and the allegation that the appeal would be stifled is not made out.
That must be, I think that's a fair point.
Thank you.
Sorry, I shouldn't put it that way. We adopt that point. Yes, and it's clear, isn't it, from that passage that he thinks the burden is on them to establish this. And so we say that actually to some extent what's happened here is that Lord Justice Patton, not surprisingly, because he was having to deal with the SocGen case, did express some of his reasoning in terms of that. But actually, we don't need that. We don't need, and that's why he had to talk about exceptional circumstances. We don't need exceptional circumstances. We say that's no part of the test. And you can do without that part of his reasoning because you can get there anyway by a completely conventional application of the burden of proof the paucity of the evidence put forward on behalf of Begana and not by Begana himself, and the conclusion that the judge reached that on access to third-party funding, as he put it, in paragraph 26. So we say that really most of the argument on points of principle falls away here. One's left with quite a narrow dispute, which really has to do with the interpretation of his judgment. But we say that on a fair interpretation, that is the proper way of reading his
You
judgment.
really have two strings to your bow. One is on a fair interpretation, that he approached it correctly.
Yeah.
And the second is, even if he didn't, he could only have reached one conclusion if he'd asked himself the right question.
Exactly. Because of the paucity of the evidence and also the surrounding evidence about the way that Mr. Begana had previously supported the company.
Well, and if we... Sorry, I beg your pardon.
I wonder about the paucity of the evidence point, because we don't know all the evidence he heard. We only have his summary when he was reasoning it in a certain way.
Well, I can tell you, and my learned friend will correct me if I'm wrong on this, Lord Hodge, but this was the only evidence on this point, this passage which he set out. It was the only evidence before him on the question of willingness or unwillingness to pay. There was nothing else.
Right.
So we say that if you're answering the question which has been asked, as a matter of principle, if a stifling defence is taken, but not otherwise, the evidence about the wealth of the third party is going to be of relevance, and not only of relevance, but it's almost bound to be taken into account. On the other hand, we accept that it's not the end of the analysis, and that there's more to it than that. We don't seek to say that the fact that there's a wealthy third party is itself the grounds for making an order. It comes in at the second stage in the analysis, which is when the party faced with the order says that my appeal will be stifled. And that's exactly the same approach that's been taken in relation to security for costs. It's exactly the same approach that's been taken in relation to conditional leave to defend in cases like MV York.
Even though you're agreed, I think, subject to what Mr. Gibbon says shortly, on the principles, this won't have been a wasted exercise so far as we're concerned on the principles, because if we accept what you both agree, then at least we will be clarifying the law relative to the SOC.
I agree with that. And, sorry.
You are, in effect, inviting, both sides are inviting us to disapprove of at least some of the reasoning in Société Générale.
Yeah. So we think it is we would submit that it is an opportunity for this court to clarify things. We would suggest actually to simplify things.
Yes.
And the approach we've suggested is really a simplification. It's a rationalisation of the law, so it has that advantage. But insofar as what my clients really care about, obviously, is winning the appeal rather than simply assisting in the development of the law. And we say...
We're the only people interested in it.
So we say that, for the reasons I've already given, that is the only fair and sensible way of reading Lord Justice Patton's decision. And we would certainly not be inviting the court to send it back to him if there's a route that they can
Route that could be avoided. Yeah.
Here you have emphasised the very considerable subventions of the company made by Mr. Begana in recent years. If there was no history on the part of the wealthy owner of subventions, would one be, in the stifling inquiry, looking at his position?
I think you might be, for this reason. One can multiply examples, but take a case where, say, the judgment sum is comparatively small. It can be seen that the owners are wealthy, that the judgment contains some important point of principle which might be of importance to those owners in some other context. It might involve a point which assists them elsewhere. If they then turn round and say, oh, well, we're not going to put up the money, the court, rightly in those circumstances, could very well say, well, come off it. I simply don't accept that.
It's all a question of the facts of a
It's all a question of the facts of the case.
Yeah.
On the other hand, if you've got a case where there's a very large amount of money that has to be paid in, you've got relatively, you've got perhaps quite widely held shares that you can see that the company has tried in the past to make a rights issue and has failed. In those circumstances, you could easily come to the conclusion that really the means of the shareholders is not particularly relevant. It all depends on the facts. But on the facts of this case, it is relevant.
Understand.
So, subject to any other questions, those are our submissions.
Thank you very much, Mr. Miles. Mr. Stonefrost. Mr. Gibbon.
Well, very, very few points in reply. Clearly, my friend has made a number of submissions which are, in essence, this is what he must be saying. Your Lordship, in the sense of what Lord Justice Patten was saying in his decision, that was a phrase he used at one point and I think repeated as well as using different formulations. Your Lordships have what he says. I respectfully adopt some of the questioning that was put to my learned friend. What my learned friend is seeking to persuade your Lordships as to what was said is simply not the sequence that was gone through. The sequence that was gone through was, if I can take Mr. Begana's position into account, i.e., it doesn't matter that he's not going to pay, then that's an end of it. And I think that is drawn out, respectfully submit, it's drawn out when you see that he talks about it in terms of things which have happened in the past, whether it's before or after July 2015.
Well, surely, if he's making the finding that Mr. Miles says he's making, then the fact that Mr. Begana has paid money is relevant, isn't it, in the past?
No, what I respectfully say, and I clearly want to avoid getting into a semantic argument about what the judge said, is in the last two sentences of paragraph 25, it seems clear to me that Mr. Begana has decided not to fund the company.
Yes.
And if I can take his financial position into account in assessing an owner's ability to satisfy the condition either prior to 9 July 2015 or thereafter, the application cannot succeed.
Yes.
So on that basis, he's looking at the past. Mr. Begana has decided not to pay. I'm assessing what happened at the past.
I see what you're saying. Sorry, I misunderstood.
And this comes back to the point that I made earlier. It's an unusual situation because ordinarily you'll be looking at 52.9 in the context of a prospective situation, as in Hammond Suddards. Here, we're applying to vary what has happened in the past. So he's not going to get another bite at the cherry if Mr. Justice Patten thinks, well, he'd pay if he was pushed. And Mr. Justice Patten knew that full well. So that was.
But how does paragraph 29 fit into this?
Well, on that basis, he's gone through, he's shown, he says, Onur has not established that it could not have satisfied the condition.
Yes, that again is referring to the past at that point or at some later point, yes.
Exactly. So he said, because I can take into account the position of Mr. Begana, because there are exceptional circumstances.
Even though he's agreed not to pay, even though he's decided not to pay.
Exactly.
Yes, I see.
There was a small point as to what the nature of our case was and whether it had changed. I don't want to dwell at that at great length, but the reference as to how we put the issue in our notice of appeal is A18, which I think is E24, MS24. And I respectfully say we did put it as a point of principle, and correctly so, as a matter of principle, in what circumstances should the court be able to take into account the position of third parties,
Yep.
whether to impose a condition, etc.
Yep.
The third point I wanted to make, and it ties in with one of the submissions my friend made in response to pressing from the court, is this tribunal in a position, if it decides that Lord Justice Patten took the wrong approach, to reach a final conclusion that nevertheless he was right? I respectfully say that's a long step to go, particularly in view of the first stage of getting to my friend's submission is you have to read Lord Justice Patton's judgment in a strained way. We say the natural reading of the judgment is that he simply decided Mr. Pagano won't pay. And if one reopens the wider question, you simply don't have the evidence before you. And I would very respectfully say this court ought to be reluctant in circumstances where such evidence has been deliberately excluded by the parties to seek to go down that route. And I would respectfully say that my friend was right in that once you have clarified in the way we're all agreed, it seems clarification is needed, the matter most properly goes back to the Court of Appeal, so it seems.
But is he right to say that the paragraph quoted in paragraph 23 is the only evidence of Mr. Pagano's position?
Well, again, it raises the question of what Mr. Pagano's position is. In terms of, has he said he won't? On that narrow question, yes.
Yeah. I mean, there's no doubt that Mr. Pagano has the money. And so the only question is whether he would, in practice, be prepared to put it up. And the only evidence we have of that is the paragraph quoted.
But if you're with me on the question of looking at whether what he's done is an abuse taken in context, the full context of his funding of the company, the taking of the money by way of dividends to which he was entitled, all becomes relevant. I respectfully think the question can be purely answered taking a single paragraph out of context.
Well, you say that's always a line that can be argued. I mean, what else is there about him? You've got the fact that he didn't pay the money over the period when he could have done by the 9th of July, the date identified in paragraph 29. You've got what he says in paragraph 23. What else, quoted in paragraph 23, what else is there?
The context is his behaviour over years in the way he has run the company. And I'd respectfully say that's to some degree dealt with by Ms. Ergoven's statement, which you've got, but it's also taken the wider context potentially of other evidence as to the business of the company, the nature of, dare I say, events in Turkey over recent years, ongoing difficulties in the Middle East more generally. I don't want to get into those wider submissions now, but they are real matters. And I'd respectfully say one should exercise great caution in the circumstance where the predicate is that the judge exercised his discretion on a wrong basis.
Mr. Given, I've been looking briefly at the written statement that you put before. It says before Lord Justice Floyd. Perhaps you would switch to Lord Justice Patton.
No, Justice Floyd made the original order.
Yes.
I'm looking at 213. Wasn't that when you appeared before Lord Justice Patton?
Yes, it is. What happened was we had thought that Lord Justice Floyd had reserved the matter
well, there
himself.
We are. Exactly. I'm looking briefly at this in order to see whether you said in your skeleton argument, or whatever you called it, you really should find on the evidence that he is, in any event, going to refuse to put up the money. Did you say that?
I adopted what was said by Ms. Ergovan in her statement, and that's what you see in paragraph 9.
Paragraph 9 on page 217.
On page 217.
Yeah.
And it was, I mean, again, without getting into it, it's been absolutely clear throughout that this is not regarded as a commercial payment by my client. My clients were defrauded by Mr. Aydin, and they were, put it neutrally in this context, disappointed in the extreme in the result of the trial. Those matters are not matters of direct concern to your lordship. But in terms of whether, as my friend says, that could be characterised as a commercial payment that falls within the words that Ms. Ergovan used, we respectfully say there is no chance whatsoever that that could be what she meant in context.
Yes, I construed what was said there was that he'd pay trade debts to keep the company afloat.
My lord, yes. And
Which is in fact what happened, apparently, because the money that your clients promised to the court wasn't paid because it was diverted to commercial debts.
And there is evidence in relation to that and the circumstances of that. My Lords, unless there's anything further.
Thank you very much indeed. Thank you. Well, we're very grateful to both Mr. Gibbon and Mr. Miles for keeping their submissions short and clear and realistic. Thank you both. We're also grateful to all those involved in preparing the written cases. We will consider this matter and let you know our decision in due course. Thank you very much. The court's now adjourned.